very good morning to all of you. Here I am Mohd Asim and presenting a topic on international transaction, technical session 4, topic 2, meaning of international transaction with regard to transfer pricing. Here is a slide. Income Tax Act 1961, Section 92B defined the terms international transactions. State that for the purpose of this section in section 92, 92C, 92D and 92E. So for the purpose of section 92B and other 4 sections, international transaction means a transaction. So section 92 says that income from international transaction shall be determined having regard to arm's length price. So as we know that transfer price is basically the price between the related parties. Actually, we are living in the age of globalizations, and due to liberalizations, multinational companies are operating all over the world, and they have opened their branches and subsidiaries all over the world. So, in order to avoid tax, they try to manipulate profits. So, they charge the price which is charged between the related parties is known as transfer pricing. So, Chapter 10, which is a special enactment, especially deal with the provision of transfer pricing. Chapter 10 titles special provision relating to avoidance of tax. So under Chapter 10, Section 92B defines international transactions. It says it means a transaction between two or more associate enterprise. So before going on further, we must understand what is transaction. Section 92F5 defines the term transaction. It says transaction includes arrangement, understanding or action in concert. So the rule of the interpretation is that if the statute does not define the term, we shall use the general meaning of the word. So generally arrangement means compromise or settlement. Then we have the understanding. Understanding is a mutual agreement, especially of private natures, which is announced or tacit kind. And action in concert means agreement in unity. So further it says that whether or not such arrangement, understanding or action is formal or in writing. It means, so the act has used the word whether or not before the word such arrangement, understanding or action is formal or in writing. So it is clear point to the fact that the agreement between two associate enterprise can be written or formal on the one hand, and it can be oral on the other. So if two enterprise enter into a written agreement, the answer to the question as to the existence of the transactions is patent. It is quite clear. If, however, two associate enterprise enter into an oral understanding or oral agreement, it becomes difficult to reduce the transactions or the agreements. So in that case, it is necessary to look into the fact and circumstances of the case and the conduct of the party in order to determine the transaction. Hence, transaction can be both. It can be expressed as well as oral. Similarly, it says that whether or not such agreement is enforceable by legal proceeding. So the act negates the legal enforceability of the act. The transaction can be legally enforceable or not. Moving on further, it's provide the condition to be satisfied before the transaction to be called international transaction. So there's a two condition which needs to be satisfied. That it must be transaction between two associate enterprise. For the section 92A of the Act has defined as associate enterprise. It means an enterprise which participate directly or indirectly or through one or more intermediaries in the management, capital or control of the other enterprise. Then two enterprise will be associate enterprise. Further, subsection 2 of section 92A has further list out certain situations under which two enterprise shall be called associate enterprise. For example, if one enterprise hold more than 26% of the voting power of other enterprise, then two enterprise shall be associated enterprise. Similarly, if one enterprise advance 50% of the loan, which is more than 50% of the book value of the asset of the other enterprise, that too enterprise shall also be associated enterprise. Similarly, if a firm guarantees, if an enterprise guarantee more than 10% of the borrowing of the other enterprise, that too will be associated enterprise. So it says that it must be a transaction between two associated enterprise, and at least one of the two party enterprise must be non-resident. So one of the party to the transaction should be non-resident. If both the party is resident, then the transaction cannot be international transactions. So for example, if there is a two US holding company, and both they are associated enterprise, and one has Indian subsidiary and other has Indian branch, and they both enter into an agreement, Indian subsidiary and Indian branch, despite the fact that the transactions is operated, initiated and concluded in India, nevertheless, however, it will be called international transaction because one of the parties is non-resident. So the condition for non-resident is very important. Further moving on, section 92b1 state that transaction in the nature of purchase, sale or lease of tangible or intangible property. So if two associated enterprise enter into a transactions of sale and purchase of tangible property can be in a physical form. It's basically property which is in a physical form, and intangible property is that which cannot be seen or touched. So section 92b1 followed by section 92b2, then there is a two explanation added by the Finance Acts 2012 with retrospective effect from 1st April 2002. So explanation has two clauses which are further divided into, first clause is further divided into 5 subclauses, and clause 2 is further subdivided into 12 subclauses. So clause 2 has defined the word intangible property. It says that intangible property includes marketing related intangibles such as trademark, brand names, logos. Then we have technology related intangibles. Then we have artistic related intangibles. Then we have human capitals, that could be related intangibles. So there is a long list of intangibles given in the Act. Further move on, it says that transaction in the nature of provision of services. Ordinary services can be business, it can be professionals, it can be government services. And in a common parlance, services means a task performed by one person in exchange for considerations. So the Act has listed out the services, which includes that marketing research, marketing management, marketing development, and we have consultancy and agencies, then we have marketing scientific research, then we have legal or accounting services. So if two enterprises enter into any kind of services, then transactions shall be international transactions. Moving on further, it says transaction in the nature of lending or borrowing. Lending or borrowing basically means it's a capital financing. Explanation has provided the meaning of capital financing, which said that any long-term or short-term borrowing or purchase or sale of marketable securities, which can be shares, bonds, debenture, derivatives, or dealing in any debts which arise during the course of a business. Further it states that any other transaction having bearing on the profit, income, losses, or asset of the enterprise. So if there is any transactions which have an effect on the profit, income, assets, or loss of the enterprise, that transaction shall be international transactions. So the explanation has provided one example. It says business restructuring, which business restructuring is simply a corporate management term which involve restructuring the legal ownerships or other structure of the organization. It can be organizational change, or it can be operational change of the business, or it can be a change in the responsibility or tasks of the enterprise. So it says that further OECD guideline define business restructuring as redevelopment, cross-border redevelopments by multinational company of function, asset or risks. So, if there is a business structuring of the enterprise, that shall be also international transaction. So, section 92B1 has been defined in very exhaustive as well as inclusive manner. Provision generally exhaustive or inclusive, but section 92B1 is a classical example where the section is both exhaustive as well as inclusive. So, section provision is basically divided into three parts. First part is exhaustive, which said that transaction in the nature of purchase, sale, or lease of tangible or intangible property, or provision of services, or lending or borrowing. Then second part says, which is also exhaustive, which says any other transaction having bearing on the profit, income, loss, or asset of the enterprise. Then third part, which is inclusive, which contains the mutual arrangement or agreement, and which is basically cost contributions agreements. Moving on further, section 92B1 followed by section 92B2. 92B2 state that a transaction entered into by an enterprise with a person other than associated enterprise for the purpose of subsection 1 be deemed to be a transaction entered into between two associated enterprise if there exists a prior arrangement in relation to the relevant transaction. So, in order to be applied section 92B2, there is a two preconditions which need to be satisfied. First, there should be a prior agreement or arrangement between the associated enterprise and the third party. So, basically cover the transaction, it will control transaction between unrelated parties. As section 92B1 contained the provision related to related parties, it contained the provision related to associated enterprise and the unrelated third parties. So, there is a two condition which needs to be satisfied. There is a prior arrangement between the associated enterprise and the unrelated third party, and second condition is that there is an involvement of associated enterprise in determining the terms of the transactions. So these two conditions must be there in order to be included in section 92B2. Further, there are some issues in a famous Hyderabad tribunal judgment in case of Swan Andhra IGMII Integrated Development Company Private Limited. It was heard that the transaction should be between two non-resident or at least one resident. If a transaction between two domestic tax resident, then transaction cannot be called international transactions. And further, section 92B2 cannot be invoked as section 92B1 is not applied. So, prior to Finance Act 2012, judgment was passed, but after Finance Act 2012, there was some clarification that the unrelated third party can be resident. It can be resident or non-resident, or it can be both. So, the Finance Act 2014, which shall be applicable from the assessment year 2015 to 2016, will make the judgment redundant. So, section 92B2 has some unresolved issues, which include that suppose if the terms and conditions between the overseas associated enterprise and the unrelated third party, it relate to the quality and quantity of material to be supplied or purchased. It may or may not affect the price of the transactions, or the Indian party determine the price of the transaction. Then whether section 92B2 applied in that case, or whether report under section 92E has to be delivered or not. Further, in case of global arrangement, where there are whether there is a overseas associated enterprise of the Indian company and overseas associated enterprise of the unrelated third party agreed on a global agreement, and that global agreement is executed by the Indian counterparties, that is unrelated third parties, Indian unrelated third parties, and the Indian company, whether in that case TP provision will be applied. So there is a lot of questions to be answered, and that answer depends upon the fact and circumstances of the case. Thus, Section 92B has defined international transaction in very exhaustive and inclusive manner, and it has provided widest possible meaning to it. Thank you.